Good evening, everyone. Welcome to our discussion of directors. As I explained on the platform, we should have had one class for the regular students in the afternoon and have another one tonight, as we usually do in person. But due to I have a feedback, so I'm going to mute all of you. If you want to speak, you raise up your hand. Some of you are making noise. Yeah. So we needed to stop meeting so that the law week activities could proceed. So having said that, I accept our apologies for having to take you through, especially those of you who don't have company law now. You should have had it in the afternoon, but it's all well and good. So let's get this thing out of our way. So as we have been discussing, we noted already that directors' important aspect of corporate governance, because if you put the members in general meeting aside, the next important pillar as far as directors are concerned, as far as corporate governance are concerned, are the board of directors. So we've understood who a director is in our previous classes. Then we have noted that it's not so much about the name, which is given to the person, but more importantly, the function that the person is performing. So we analyzed section 170 of Act 992, and we also noted that where you have, for example, not been appointed a director and you are behaving like a director, in terms of liability, you'll be held to the same standard of liability as if you have been appointed the director. And we made it clear that according to Professor Gawa in his commentary, which accompanied the predecessor legislation to the current Act 992, that is Act 170. The reason for that provision, which is reenacted in current section 170, subsection 2, is that if people are not appointed directors and then they behave as directors, they should be held liable in the same way as directors. Nevertheless, they should not be given the recognition as directors. Yeah, so we discussed that. And again, we also look at other types of directors. We did make the point that de facto director, shadow director, is not a language which is actually used in our legislation. Although, if you look at the English company legislation, it is there. And for that matter, because we are used to the English tradition, we come across it in our learning. And we did note that if you examine section 170, section 2, A and B, you'll notice that they reflect the substance of what we mean by de facto director and also shadow director. And we even cited the case of Commodore against the Fruit Supply Limited to illustrate that particular point, where Mr. Ato Kwashi had not been appointed and he held himself out of the company, projected him as if he was a director and so on. You remember what happened in that particular case. Then we also distinguish between executive director and non-executive director. We said that executive director is one who is a director in addition to the traditional duties as a director. He or she also has a paid position. So he's an employee in one breath, and in another breath, he's also a member of the board of directors. So we discuss that as well. And then we also discuss a special type of executive director known as the managing director. And we noted that for managing director, is also executive director. The only difference is that unlike other executive directors, the managing director is given some of the powers or functions which are ordinarily exercised by the board of directors collectively. And again, we noted that because of the special position that the managing director occupies in contradistinction to other executive directors, if, generally speaking, if a managing director should lose his directorship, that is, if he's removed as a director, then he will also lose his position as an employee executive director, qua managing director. That is to say that his job as a managing director is very much tied to his directorship. And unless in the contract leading to his appointment as a managing director, there was maybe like a specially negotiated clause that should he even lose his directorship, he's not going to be removed from his job as an MD. Otherwise, the general position we saw is that once you are a managing director, in terms of section 184 of Act 992, you lose your directorship and you're no longer a managing director. Then we also discussed non-executive director. Non-executive director, those directors who play the traditional role of a director in the sense that they take part in the boardroom deliberations, they serve on the board subcommittees, and beyond that, they go to their work elsewhere. They are not paid employees of the particular company in respect of which they hold directorship. Then we also discuss another type of directors, what they call the substitute director as against alternate director. We notice that a substitute director, in terms of section 180 of Act 992, is a deputy director for a named director. In other words, someone who has been appointed like any other director, but he is supposed to be, if you like, a standby director for a particular director or directors, as the case may be. And for that matter, he functions or he exercises directorship when the named director is, for example, absent. And we noted that his remuneration is the responsibility of the company, not the responsibility of the particular director for whose sake the substitute director was appointed. And for that matter, we also noted that he should be qualified in the same way as a substantive director, and he could also be removed in the same way as substantive director could be removed. And we noted that if his named director is removed, it does not mean that he is also going to lose his directorship. Good. Then we talk about another category which contrasts with the substitute director, that is alternate director. And with respect to alternate director, we noted that he is a director who is not appointed by the company. He is actually nominated and appointed by or approved by the board of directors, and he's nominated by a director who is unable to exercise his directorship or is absent for a period not exceeding 6 months. And because the alternate director is actually nominated or picked by the director who contemplates that he is not going to be available to perform his function as director for a period not exceeding 6 months, that nominating director or that appointing director bears the responsibility of paying the remuneration of this director who is going to be appointed as an alternate director. And again, we noted that the alternate director must also accept his appointment in writing, and also added again that despite the fact that he is appointed by a substantive director or is nominated by the director who is going to be away, he is not an agent of the director who is appointing him, because every director bears a personal responsibility and is supposed to exercise independent judgment. And for that matter, if you fail in your duties as a director, you'll be held personally liable in accordance with the law. And you could not be held to say that, well, I was just an agent of a particular director who appointed me as his alternate. And for that matter, I was taking instructions from him or from her. It does not work that way. That notwithstanding, the remuneration or the payment for services and time of the alternate director is not borne by the company. It is rather borne by the particular director who is appointing this alternate director. So let us keep that in mind as well. I think that marks end of discussion of the types of directors. And again, we also discuss what we call the residence requirement. We discussed section 182 of Act 992, which governs residence of directors. And we did make the point that section 182 of Act 992 requires that at every point in time, there should be at least one director present in Ghana, that is resident in Ghana, in the Republic. And we sought to discuss the rationale for such a provision. On the face of it, if you look at it, especially so in the light of advancement which have been made in technology of communication, one may argue that a provision in section 182 is quite superfluous and even unwarranted. Why? Because now, just look at what we are doing. We're on various locations, and we are more or less having a session as if we were in person in the classroom. And if that is possible, then it should be possible for an absentee directors to be able to get things done as far as the company is concerned. So one will have said that, what is the wisdom of trying to have section 182 that the directors or some of them should be resident in Ghana? Well, we look at the GAWES report, and then we also sought to reason around it. And we made the point that we could, for example, understand that provision in the sense that where a director, for example, has defaulted in exercising his responsibility as a director, he may sometimes bear not only civil liability, he may also sometimes even bear criminal liability or responsibility. And as we know, as far as sovereignty of Ghana is concerned, it's not possible for absentee directors, the director somewhere outside Ghana, for example, to be arrested and prosecuted. Now, if you have GAWES report, the predecessor provision of current section 182 of Act 992 is section 189 of the repealed Act 179. And if you look at GAWES commentary around it, I think it's very similar to the reasoning that we have propounded to justify the resident rule under section 182 of Act 992. And what does GAWA say? GAWA says that, let me quote, this session has been added at the suggestion of Association of Accountants, Ghana. It is clearly undesirable that a company should be left without any director within the jurisdiction. And having regard to the two immediately foregoing session, there can be little excuse for this occurring. Then he will say, I am alive, Gawa speaking, I'm alive to the fact that the session may be difficult for this, and that it will be unfair penalties, except in the event of a willful default. This seems to be another case where use should be made of the self-enforcing formula, which I've already suggested in section 21, by disabling the competition on contracts made while it is in default. Yeah, in other words, Gawa is trying to say that in order to ensure that companies will comply with the residence requirement, if you read, for example, subsection 2 of section 1A2, where a contract has been made by the company at the time that no directors were all absent in Ghana, as it were, the company will not be able to enforce that contract, except that where it affects a third party, the third party can enforce the contract against the company, and so on and so forth. Then we also move on the last time to discuss qualification and disqualification of directors. So we look at section 173 and we look at the details of it, but we sought to explore the wisdom or the rationale underlying the rules on qualification of a director. Now, we did note that when a person is appointed a director, the director has so much discretion, or has a lot of room to make decisions here and there. And stakeholders of the company, the shareholders, the members, will not be able to police everything that the director will have to do in terms of discretionary judgment and choices. And for that matter, you want to be sure that you are putting the destiny of the company in the hands of the right person. And the best opportunity you have to do that is at the time that you are selecting somebody to be made the director. And that is why you have your checklist to determine whether the particular person that you are appointing as a director, for example, is the one that you trust can actually perform the role or the function of a director. And that is why the qualifications are important. And if we look at 173, as we discussed, especially subsection 5 of 173, quite apart from the detailed qualifications, that the person should not be infant, the person should not be adjudged to be of unsound mind, the person should not be a body corporate, the person should not be someone who have been restrained by a court order for having been involved in fraudulent transactions relating to another company before, and all that. Now, subsection 5 of section 173 permits the company to even add to this qualification, meaning that it is permissible for the company to stipulate other things which should be met before a person could be appointed a director. And that is why we indicated that if you look at even certain special types of companies, for example, as in the case of like the banks and other special deposit taking companies and all that, you notice that the Bank of Ghana even prescribes additional qualification which should be met by those who are going to be directors of a company of a bank as it were. Yeah, so that is why qualification is important. And again, we also touch on the issue of share qualification, that should directors, for example, have shares in the company. Under section 174, we noted that it is not mandatory. However, where the company considers it necessary that directors should have shares, then if you are appointed a director and you do not have the requisite shares, the law allows you a period not exceeding 2 months to build the required number of shares. Yeah. And we ask the question, is it really necessary for shareholders to insist that directors should have shares? Well, one school of thought says yes, it is important that directors have shares in the company, because when they are making decisions and all that, they will know that they also have a permanent stake in the company. And for that matter, they will not be a recipient is saying that the regular class didn't get to session 174. Okay, so if regular class did not get to session 174, then let us continue from session 174. Okay. Yeah, so session 174, at this stage, let me say that if you don't have your AG 992 already with you, please get your AG 992 by your side, so that as I make reference, you'll be able to look at your law. Good. So for the sake of our regular students who have just drawn my attention to the fact that they didn't get to discussion of session 174, we will quickly dispose of that. So session 174 requires that, section 174 is to the effect that, as a general rule, directors are not required to have a share in order to be a director. That is the general rule. The exception is that where the company, by its constitution, requires that a director must have a certain number of shares, then when a person has been appointed a director, that person has a period not exceeding 2 months to take steps and acquire the required number of shares as stipulated in the constitution of the company. Now, what that means is that after the expiry of the 2 months, if you haven't built up the number of shares required, then of course, automatically you will lose your directorship because you have not have qualified, since having shares has been prescribed in the constitution of the company as a requirement of being a director. But as I said, if the constitution of the company does not actually insist that a person appointed a director must have shares, then there is no such requirement. Then we ask the question, what at all is it there in, for example, a company putting in its constitution that directors must have shares? Well, a reason which some people may assign is that if directors have shares in the company, the directors will see themselves as having a permanent stake in the company. And for that matter, when they are taking decisions or they are running affairs of the company, they will take right decision which will not jeopardize the ultimate welfare or well-being of the company. Another school of thought is that, well, where directors are shareholders, it can also have its own negative impact, because directors may think more about maximization of shareholder value. That is, grow the profit of the company. Because when, as we saw from discussion of shares last semester, when you grow the profit of the company, you are going to have more dividends, and dividends are the returns on the shares that you have. so that if a director is a shareholder, profits increases, there'll be more dividends, and he will get more money. So some people will say that that in itself may not always be in the best interests of the company, because there are so many other constituents, not only shareholders. We have employees, you have the environment, you have the general public and all that. And all these constituencies have got interests which should be advanced by the company in one way or the other. So therefore, where you have directors coming from only one constituency as shareholders, they may only take decisions which will advance the interests of the shareholders to the detriment of other constituencies. Of course, we cannot exhaust debate on whether it is necessary to have share qualification for directors or not, but these are some of the ideas which are actually out there. Okay, so if there is no question on that, we move on to discuss some other minor things before we come to appointment and removal of directors. That is what we call the publication of names of directors. Publication of names of directors. If we look at section 186, sorry, before I do the publication of the name of directors, before we do that, let us tie in the share requirements with registration of the register of directors holdings in terms of section 210. So please jump to section 210. Section 210, that should be read together with section 174. So section 210 requires that there should be a register, right? Register in which shares which directors have in the company as well as in associated companies are disclosed. And the register, which is supposed to contain information about the various shares, how many shares directors have in the company or an associated company, and maybe how many or how much loan has the director got in the company and all that. All these are supposed to be disclosed in a particular document we call the Register of Holdings. And this is available for anybody who is interested in trying to know the true state of affairs as far as the holdings of directors are concerned, to go and look at that. You may be wondering, why should there be a register containing information about the various shares which a director has in the company or in associated company, or the debenture, or that is a loan capital which a director has in the company or associated company? Well, later on, when we are discussing duties of directors, you will notice that directors are seen as fiduciaries. They are supposed to exhibit utmost good faith. They're supposed to be honest and avoid conflict of interest. And for that matter, it is important for us to know whether directors have shares in the company, they have shares in some other company, and so on and so forth. Of course, one other purpose for the register of holdings of directors will also enable us, especially where section 174 applies. If I say section 174 applies, that is to say that where the company by its constitution, for example, has stated that to be a director, you must have shares. Then where that is part of the rules of the game, we must have a mechanism of verifying at every point in time whether that requirement, for example, is met. And part of it is the search, which you can conduct in the Register of Directors holdings. So take note of section 210, Now, later on, when we are discussing the duties of directors, we will still find section 210 relevant. So let us keep that in mind. Now, because of how I have muted you, if you want to ask a question or make any comments, please, you just raise up your hand so that I will allow you to do that. Good. So I was going to discuss section 186, that is publication of names of directors. It is a very simple thing. It is a legal requirement that all circulars, including business letters or letterheads of the company, must bear the name of the directors. This is very important. And the name of the directors include the substitute directors. Alternate directors are excluded. I'm wondering, you may want to find out whether and why does the law exclude alternate directors from being stated or published on the letterheads. Simple. You know, alternate directors are appointed for very short term. It may even be for 1 week, 2 weeks, 1 month, or up to 6 months, as we saw. And for that matter, it will not make business sense if, for example, you have to publish the name of alternate director as part of the business records of the company. But for substitute director, because a substitute director is treated as a regular director, his or her name included in the stationery of the business letterheads of the company. And again, a person may ask, why should we publish the names of directors on the letterheads of the company or other business? Can anybody tell me the reason? Anybody? Why do you think the law provides, in terms of section 186, says that we should provide the name of the directors on letterheads and other business documents of the company? What do you think is the wisdom or the rationale behind that? Okay, if you are not talking, I'll call you as I see your name. Ajubi Aduprempe, can you mute yourself? Ajubi Aduprempe.
Yes, please.
Yes. Can you tell us what, in your view, is probably the reason for requiring per section 186 of Act 992 that names of directors should be published clearly in trading circulars or business documents of the company?
I think since the directors run the affairs of the companies, just right that their names will be on the letterheads and other documents to show who the directors are in case of just for the sake of us knowing who the directors are, to be able to know who to be held accountable, I think.
Okay, Ajubi, you've made noble effort. Can anybody add to that? Yeah, I am back. Yeah. Yes, can anybody add to that? Yes, KKI, Yes.
I think that on the face of it, it's evidence as to who the directors of the company are. And then in the case of a dispute, reference can be made to that. And as Ajubi also said, for the sake of accountability.
For the sake of accountability. Okay. 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 So KK and Ajubi. Thank you. But maybe the other thing I wanted you to have also address your mind to is the, for example, if the names of directors are published, right? In terms of, if you remember when we were discussing qualification of directors, in terms of section 177, restraining persons from managing companies. And if you look at section 177, for example, any person who, for example, has information that, like if you look at it, please go to section 177 and look at subsection 6. Like any member or officer of the company, a person who can demonstrate an interest in the case, the registrar, trustee in bankruptcy, liquidator, and so on. Now, if you are someone who comes within section 177 subsection 6, and you, for example, see the name of Mr. X on the letterhead of the company as a director, and if, for example, you know that Mr. X has previously been banned by a court order, or is a certain matter of a court order that having been involved in some fraudulent transaction relating to a company or a company which has gone through bankruptcy and all that, he should not be a director. Now, if you see his name on the letterhead as a director, and if you are someone who cares to actually take it up, because you have probably an interest in the company in one way or the other, you could go to court and, for example, get him struck down. So as you rightly said, to enhance accountability, to actually reinforce that those who are directors are people qualified, and we also know the directors, they are not faceless and all that. All those things make it important for us to have the names of the directors published. Okay, so having said that, we are going back to the basis. We are going to look at the issue of appointment and removal of directors. But before that, I think I asked you to read the case of Okujetu and the Irani brothers. Did you do that? Yeah, you're a good student, so I trust that you did that. So I want to give you the benefit, right? I want to give you the benefit of the doubt and say that you did read when I asked you to read it. So appointment of directors. As far as appointment of directors is concerned, we have to remember that we have the initial appointment, what we call the appointment of first directors, and then we also have the what you call the subsequent directors, and also filling of a casual vacancy. Because I want you to take your act, that is why I have taken off the screen, so that when you have your Act 992 beside you, and you can be looking at the law itself. So first directors. So please, let's look at section 13 Jane. If you go to section 13 Jane, it states what the law is with respect to how first directors are appointed, or the initial directors are appointed. So 13 J, if if you look at it, can somebody read for us? Whose hand is up? Okay, Karen.
Yes, please. 13G. The following particulars of each proposed director of the proposed company I. The present full name and any formal name. II. The particulars of any business occupation. N. Other directorship held by the director as provided by Section 215 and III. The residential, occupational, postal and electronic mail addresses and telephone contacts.
Okay, so if you look at the 13 Jane, if you pay attention, it said proposed directors. And don't forget, 13 governs the registration or the incorporation of the company. So now we have subscribers, those who are actually working, the subscribers and promoters, those who are working to bring about the company, to get the company registered. So they will have to appoint the first directors. And that is why, as part of the application document, they must provide the information or the particulars about each of the proposed directors in terms that we saw under 13J, I to II. Now, to ensure that the first directors are still qualified, the lawmaker has provided a mechanism to check that. So look at H. Yes, H, Karen. I think she's gone or she's muted again. Okay, so Karen, you are going to, okay, I'm making you a co-host so that you don't need to, I've made you a co-host, okay. Yeah, Karen, so you can mute yourself. Yeah.
Thank you very much. H. A statutory declaration by each proposed director of the proposed company, indicating that within the preceding 5 years, that proposed director has not been I, charged with or convicted of a criminal offense involving fraud or dishonesty, II, charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company, or III, declared insolvent, or if that proposed director has been insolvent, the date of the insolvency and the particulars of that company.
Okay, now, if you look at the H, it is trying to ensure that despite the fact that these directors are going to be proposed for the first time, since you are now trying to register the company, they must still be qualified in terms of section 173 and section 177. So therefore, if you look at the substance of section 13H, that you must do statutory declaration. Last time we explained what the statutory declaration is. So let me reiterate again. In law, there are two ways by which you make a solemn statement as to the truth, that you are telling the truth. One way is to do affidavit. Another way is to do statutory declaration. Affidavit is a statement under oath made by the deponent saying that the things that he's saying are true. It is usually used in relation to matters pending before court or matters which are going to court. So that is affidavit. On the other hand, where you are dealing with something and is not necessarily pending before court or going to court, and you still need to make a solemn statement as to the truth or the veracity of what you are saying, you do that by statutory declaration. So that one too is a statement under oath, that the things that you are saying are true. So if you are proposed as a first director, you are supposed to swear in the form of statutory declaration that you are clean within, as far as the preceding 5 years are concerned, regarding all the offenses which have been listed relating to setting up of a company or running of a company, that you've not been involved in any fraudulent activities and so on and so forth. And that is very similar to what section 173 and 177 also seeks to achieve. So this is how first directors are appointed. But the other point to note is that every director who is appointed must accept the appointment in writing. So appointed director must consent in writing. So if you look at section if you look at section 13, I. Section 13I requires consent of each proposed director. So even for first directors, you are supposed to actually give your consent in writing, as it were. So that is very important. And if we look at the well-known case of a politics against Plastico number 2, politics against Plastico number 2, which we've met before. This is not like the first time that we are meeting politics against Plastico number 2. A person was appointed the director, and his consent was not actually elicited in writing. And subsequently, when application was brought in court to have his appointment declared null and void, the courts had no difficulty at all in saying that insofar as the law is quite clear that where you are appointed a director, you must actually accept the appointment in writing. Accepting it in writing was a condition precedent for valid appointment. And for that matter, where the evidence suggested that you had not actually consented in writing, the appointment was not valid. So please, let us keep that in mind, that a person to be appointed a director must actually accept the appointment in writing. Now, so that is about what they call like the first directors, how they are appointed. But we must also have recourse to section 29, subsection 2, regarding appointment of subsequent directors, appointment of subsequent directors, and also how to fill casual vacancies. So if you go to section 29, subsection 2, Karen, can you take us?
Yes, please. Where the Constitution empowers a person to appoint or remove a director or any other officer of the company, that power is enforceable by that person, although that person is not a member or officer of the company.
Okay, so by that provision, that is section 29, subsection 2, what we are learning is that the constitution of the company, for example, could give power to anybody to appoint a director, and that person can legitimately appoint a director, despite the fact that the person is even not a member of the company, as it were. So let us keep that in mind. Very important. Now, that is just the general position. So in terms of the subsequent directors, if I say subsequent directors, that is after the first directors or other directors that to be appointed are called subsequent directors. So how are they appointed? Section 29.2 has given us a clue that yes, it may well be that the company's constitution has provided how or who should appoint, so that will be respected. Otherwise, subsequent directors are appointed by members in terms of section 172, subsection 4. So if you look at section 172, subsection 4, Karen? Is Karen there? Okay, so if you look at the 172, 4, the constitution of a company may provide for the appointment of a director or directors by class of shareholders, debentures, creditors, employees, or any other person. So you notice that 29.2 is to be read with 1724, just to reinforce that the constitution of the company may actually provide who and who are to appoint directors. And I've mentioned it before that someone may even give a loan to the company, like in the form of being a debenture holder or some other form of credit. And the person will actually insist that he wants to be given the power to appoint directors or a certain number of directors. And that may sometimes require amendment to the constitution of the company in order to accommodate such a demand, because the company needs the money. And that is what the person going to provide the money would like to see before he gives the money. So where that is the case, then, for example, there may be the need for putting it explicitly in the constitution of the company that this person or that person is to appoint this number of directors or that number of directors. So let us keep that in mind. So 172 section 4. And again, we must also pay attention to 172 subsection 5, which makes the point that where, for example, someone has not met the share, sorry. Karen, are you there?
Yes, please.
Yes, can you take 172.5 for us?
Yes, please. 172.5. Despite a provision to the contrary in the constitution of a company, a casual vacancy in the number of directors may be filled by A, the continuing directors or director, although the number of directors may have been reduced below that fixed as the necessary quorum of directors, or B, an ordinary resolution of the company in general meeting.
Okay, that is fine, but we will come and talk about the casual directors, casual vacancy very soon. But I wanted us to look at some special arrangement which relates to appointment in private companies as opposed to public companies. So, for example, if we look at subsection 172.3, in terms of how subsequent directors are appointed in a private company, we are referred to section 300. So can we look at section 300, how subsequent directors are appointed in a private company?
Yes, please. Section 300. Appointments and removal of directors of private companies. 301. The appointment and removal of directors of a private company may, subject to sections 171 to 176, be regulated by the registered constitution of the company. 2. In the absence of a contrary provision in a registered constitution of the company, each of the existing directors shall continue to hold office until the director vacates office under section 175 or is removed under section 176. 3. A company may at any time by ordinary resolution fill a vacancy in the number of directors and may at any time by ordinary resolution increase the number of directors, but the total number of directors shall not exceed the maximum prescribed by the registered constitution of that company, if it has one.
Okay, yeah, so Section 300 is very instructive on how a private company should get subsequent directors. And we've explained subsequent directors to mean directors appointed after the term in office of, if you like, the first directors that were appointed at the time that the company was registered. So 300 is making the point that where the constitution of the company has made arrangements regarding how directors should be appointed, then that will be the governing position. On the other hand, where the constitution of the company is silent, or the company does not even have a registered constitution, as we know is a possibility, then what will happen is that the directors will continue to hold office. And as we know, usually every AGM, right? Every AGM, annual general meeting, as you saw in discussion of members' meetings, we have election of directors who replace retiring directors. So the first directors will actually be deemed as having retired at the very first AGM that we have, and then there will be election to elect who are going to be the directors of the company. And where there is a vacancy, right? Where there is a vacancy in the number of directors, before the term of office of the director, or before the term of office of the board of directors have actually come a full cycle or actually exhausted, then we will say that there has been what we call like a casual vacancy. We come and look at the 172, but because 300 subsection 3 is referring to the fact that at every point in time where there is a vacancy in the number of directors, the shareholders may pass an ordinary resolution to actually increase the number. So therefore, if, for example, the company has maybe a prescribed term, either a director will serve for 2 years or 3 years, but before the 2 years or the 3 years have elapsed, the director is removed or cease to be a director or die or whatever, then there's a vacancy which will have to be filled, and then the members will have to pass ordinary resolution to fill that. So that is the position as far as private companies are concerned. But when it comes to public companies, the situation is a bit different. So if you look at section 172, subsection 3B, how subsequent directors are appointed, and also how casual vacancy is filled in the case of public companies, we are referred to section 325 and section 326. So let us look at section 325. Aaron? We've lost it. Now, I want us to pay attention to section 325 well. I was going to introduce, Karen, are you there?
Yes, please.
Okay, it's introducing us to a concept, what we call the rotation principle of directors. And this applies, as I indicated, to only public companies, not private companies. So when you are applying the rule, sometimes you have to be mindful of whether we are dealing with private companies or public companies. If we are dealing with private companies, the governing provision is section 300, which we have already seen. And the position there is quite simple, that when you have the first directors will continue to remain in office until maybe if the constitution is silent, until there's a vacancy, and then the members will fill by ordinary resolution, as you have seen, and so on. But in the case of public company, it is different. So let us look at section 325.
Section 325, rotation of directors of a public company. Subject to sections 172 to 176 and sections 326 and 327, and except as otherwise provided in a registered constitution of a company. The following rules shall apply to the retirement and appointment of directors of a public company.
Good. Before you continue, let us note, and I mentioned chapeau the other time. You see that we have a lot of chapeau in the provisions. So if you look at the 325, the preambular statement, it's saying that all that we are going to look at are applicable where we do not have contrary provision or contrary arrangement in the constitution of the company, or where it does not disagree with the other provisions that we have seen, the general provisions on appointment and qualification of directors and all that. So these are the default rules which apply regarding how subsequent directors are appointed in a public company if the particular public company does not have a constitution which makes some other arrangement. So let us look at the default rules now.
A, at the first annual general meeting of the company, every director shall retire from office, and at the annual general meeting in every subsequent year, 1/3 of the directors for the time being, or if the number of directors is not 3 or a multiple of 3, then the number nearest 1/3 shall retire from office.
Okay, let me just explain. Now, please compare 325A with what we saw in the case of section 300 subsection 2. Now, if you look at 300 subsection 2, which applies to private companies, we are told that in absence of a contract provision in a registered constitution of the company, each of the existing directors shall continue to hold office until the director vacates office under section 175 or is removed under section 176. That is to say that in the case of private companies, after getting the first directors, we do not have any straight rules or fixed rules regarding when the term of office of the first directors will come to an end. And that is why we are told that, yes, either they resign, they die, or they are removed, as it were. But if you compare it with what we just read, with regards to public companies under section 325A, that the first directors, that's the directors who were proposed during the registration of the company, their term of office will automatically come to an end at the first AGM, the first annual general meeting. And then the company will be at liberty to elect people to replace them. So that all of them at the first AGM, they'll retire. And then in the subsequent or the next AGM, at every AGM, 1/3 of the directors will retire. So for example, if you have 9 directors, 1/3 will simply mean 3, right? If you have 6 directors, 1/3 will mean 2. So at every AGM, 2 directors, for example, will be stepping down, so that we let 2 more to replace them. So that is the rotation principle, and that is how it works in the case of public companies. But if you look at the B, yes, continue. Okay, so she's not there. So let me just summarize the provision so that we can move fast. Now, if you look at the 325B, it makes the point that usually, if we need to determine whose turn is it to retire, we will look at the date of appointment and those who have served the longest they will be considered as being ahead of the queue to retire, so that new people can be voted to elect them. Yeah, so that is another aspect of the rotation principle of directors in the public companies. But if you take a managing director, an exception is created for managing director as far as public companies are concerned. A managing director, if you look at the 325C, shall not, while holding office as managing director, be subject to retirement by rotation or be taken into account in determining the rotation of retirement of directors. So in a public company, all the directors are subject to the, if you like, the rotation principle regarding their directorship. But in the case of a managing director, he is not subject to the rotation principle for obvious reason, because he is a special executive director who runs affairs of the company, exercising some of the powers which are ordinarily exercised by the board of directors. And for that matter, he has a special arrangements of appointment, and he doesn't have to step down because he has been in the queue for quite some time ahead of some others. But where the constitution of the company does not actually prescribe or forbid it, a retiring director is eligible for re-election. So if you are even stepping down in accordance with the rotation principle, it does not mean that you cannot be re-elected. You can offer yourself for re-election. Now, the challenge is that if you look at the recent corporate governance directive, which the Bank of Ghana has actually issued to govern directorship in banks and other finance and deposit-taking financial institutions, the Bank of Ghana as a regulator has introduced some kind of like capping that if you've been a director, for example, for a continuous period of, let's say, 9 years and so on, you will not be eligible to be selected a director until you've gone to stay home for, I think, a cooling off period of about 2 years before you could, for example, offer yourself for re-election and so on and so forth. Yeah, so let us keep that in mind. So you get to know that for public companies, the rules are a little bit different compared with the private companies. Now, let us look at the F. Karen, F, 325F. Then our reader has disappeared. Okay, so if we look at the, let me probably get another person as a supporting. Yeah, who offer himself or herself? So that you are made the co-host. Okay, Jude. We are Jude. Okay, so Jude, you are made the co-host, so you can mute yourself. Jude, I think you can mute yourself.
A person is not eligible for election to the office of director unless not less than 3 days and not more than 28 days before the date appointed for the general meeting, a notice in writing of the intention to propose that person for election, signed by a member entitled to attend and vote at the meeting, and of the consent to be elected as a director, signed by the person proposed, is lodged at the registered office of.
Good. Okay. Yeah. So where the company's constitution,
Jane, on an increase.
Okay. All right. All right. Thank you, Jude. Yeah. So where the company's constitution is silent on detailed rules regarding how directors are elected, then these default rules apply that latest 3 days before the AGM in which the election is going to take place, if you are interested in offering yourself to be elected, you must have your nomination together with your consent in writing to be a director, if you are so elected, lodge lodge with the company before the meeting is held and so on. And you cannot also submit this earlier than 28 days. So 28 days to 3 days before the election, that is the period that you can do that. Now, I want us to pay attention to what they call the voting rules. We come, because there may be some vacancies, right? There may be vacancy regarding the position of a director. That is, someone is a director, it's not yet time for annual general meeting for election to be held to replace retiring directors. And let's say that the person has ceased to be a director by reason of maybe any of the things that we have seen, as to maybe resignation, death, and so on. So where that is the case, then we say that there has been a casual vacancy. And if you look at the case of politics, we look at the politics against Plastico Limited #2. The court was quite clear on what constitute what you call the casual vacancy. And Justice Emisa made the point that if we talk about casual vacancies, we are talking about any vacancy other than one occurring by a fruition of time, other than the one occurring by a fruition of time or through the director retiring by rotation. In other words, apart from where you have served your term or your duration as a director, or where you have to retire by the rotation principle, if your directorships will become vacant in any way other than these two, we call that a casual vacancy. And where there is a casual vacancy, then we must have records to section 176 no, sorry, 1725. 1725, yes.
1725. Despite a provision to the contrary in the constitution of a company, a casual vacancy in the number of directors may be filled by A, the continuing directors or director, although the number of directors may have been reduced below that fixed as the necessary quorum of directors, or B, an ordinary resolution of the company in general meeting.
Okay, so having understood the casual vacancy as a vacancy other than one occurring by the fruition of time or through directors retiring by rotation principle, section 1725, which Karen has read, is telling us that when there is such a vacancy, then the continuing directors, that is the directors who are still at post, directors who are still in office, they have the power to fill that vacancy. And that power can still be exercised, even where the directors do not have quorum. Now, from law of meetings, we know that quorum is very important before you can have, a valid meeting. And we know quorum to refer to the minimum number of, people or participants or attendants required to be present before the meeting can commence and validly transact business. Now, in the case of casual vacancy, section 172, subsection 5 is telling us that even where quorum cannot be met, it is still permissible for the continuing directors to appoint someone to fill the casual vacancy. Now, you may want to ask, are directors not going to abuse this power to fill casual vacancy? The answer is no, because when we are discussing duties of directors, you will notice that under section 190, right? Under section 190 and 191, when directors are using their power to fill casual vacancy, they are supposed to observe the standards of good judgment, good faith, utmost good faith, honesty, a duty of care, and all that expected of them as directors in relation to the company, so that they must appoint someone who is qualified to be appointed a director. Someone who will have been qualified if the shareholders were using the usual procedure to appoint a director. It is that type of person who should be appointed by the continuing directors in terms of section 172, subsection 5, to fill the casual vacancy. And that is why, let's jump to subsection 6, Karen or Jude.
Subsection 6. In exercising the power to fill a vacancy under subsection 5, the director shall observe the rules laid down in sections 190 and 191 and shall not appoint a person to be a director unless the directors have taken reasonable steps to satisfy themselves of the integrity and suitability of the person to be a director of the company.
Okay, unquote. Yeah, so ordinarily, it's not directors who are supposed to appoint directors, but because of the need to avoid vacuum and ensure that the directors can continue to attend to the affairs of the company, they are given the power to appoint someone to fill the casual vacancy pending the time that the company will go for meeting and appoint substantive directors. But then the directors who are going to appoint this person to fill the casual vacancy is required to do the right thing to ensure that they will take the reasonable, adequate steps to verify that the person they are appointing meets the test of integrity, and that the person is suitable in terms of the qualification and disqualification principles that we have been discussing. Now, that is not the only way in which casual vacancy may be filled. It may also be filled by ordinary resolution of the company in general meetings. The members can go for general meeting, and this general meeting here is not referred only to annual general meeting. It can also be extraordinary general meeting. So let us keep that in mind, in the sense that even where it is not yet time for the company to, for example, have meeting in order to appoint, to have an annual general meeting, as you know, in order to elect directors to replace retiring directors. We may get members who may probably requisition that there should be extraordinary general meeting in order to, for example, appoint someone to fill a casual vacancy. Now that is possible if the members want to actually make use of the facility provided under having extraordinary general meeting. That is why section 1725B is saying that such a vacancy may also be filled by ordinary resolution of the members. So let us keep that in mind as well. Any question before continue? Let me see some this up. Okay. Now, another way in which directors may also be appointed is by the court. The court may also appoint directors. And you may be wondering, how can the court actually play a role in appointment of directors? So let us look at section 172, subsection 8. Section 172, subsection 8.
In the event that A, there are no directors of a company, or the number of directors is less than the quorum required for a meeting of the board, and B, it is not possible or practicable to appoint directors in accordance with the constitution of the company, a shareholder or creditor of the company may apply to the court to appoint one or more persons as directors of the company, and the court may make an appointment if the court considers that it is in the interest of the company to do so.
Okay, good. Yeah. Now, this particular provision should ring a certain bell. There's a similar thing in relation to members' meeting. Do you remember that when we were discussing members' meeting? In the case of Address Mining and Ashanti Gold, do you remember that? In other words, do you remember anything regarding how the court may order a meeting to be held? You don't remember anything like that? Oh.
Yes, please.
Okay, tell me, Karen, if you do, or Jude, or anybody, can put up your hand.
Karen.
Yes, who is by the side of Karen? Jude? Oh, you forgotten. Okay, when we're discussing meetings of members, when it comes to requisition meetings or convening meetings, you came across what we call the impracticability test. That is the power of court to convey a meeting. And if you remember the Address Mining against Anglo Gold Ashanti, if you remember that case, the predecessor provision, section 162 of the old Ad 179, which has been reenacted, which actually, the same, it's even be retained as 162 coincidentally, because the power of court to order meeting, it was 162 in the old Ad 179, and coincidentally, it is still section 162 in Act 992, where we are told that if it is for good reason, it is impracticable, right? It is impracticable for meeting to be held according to the usual principles or the usual way in which meetings are organized or called in order. Then the courts, upon application, may, for example, order a meeting to be held in ways that it will direct. So similar idea is carried into appointment of director in terms of section 172, subsection 8, that the courts may intervene regarding how directors should be appointed under certain circumstances. Okay, Now, where, for example, we have no directors, don't forget that the law says that you should have a minimum of 2 directors. It may so happens that either the 2 directors or all the directors, whatever the number, either they are dead or they are removed, as it were. So they are not in office, so there's no director. And that can be done. For example, you can have the board of directors of a company being dissolved, especially in the banking and the financial industry, probably at the instance of the regulator. And where that is the case, in order to address the vacuum, you may probably go to court. So here it is not practicable. It's not practicable in the sense that directors are those who will usually organize meetings and so on and so forth. And there are no directors, or for some reason, it is not practicable for the requirements of the constitution of the company regarding how directors should be appointed to be met. So in all these situations, the law in terms of 172 subsection 8 and 9 permits the court to make necessary orders appointing directors according to terms and conditions that the court may deem fit. Yeah, so that is another possibility. But again, the courts will not use this power anyhow. It is, if you like, a last resort mechanism. And that is to say that all the procedures which govern appointment of directors must actually be made use of. It's not the case that every now and again, then you rush to the court for the court to intervene in appointment of directors. It is not done that way. So we are going to look at remuneration of directors before we discuss directors' meetings, and then next time we discuss their duties and we are done. So remuneration of directors, a very important subject in talking about corporate governance, because most of the troubles, they actually emanate from this particular area. So let us look at the section 185. 185.
Section 185, remuneration and other benefits of directors. Subsection 1. Subject to this section, the fees and any other remuneration, including salary, payable to the directors in whatever capacity, shall be determined from time to time by ordinary resolution of the company and not by a provision in an agreement.
Okay, now before we even discuss this further, let me ask you, class, is it a good idea to allow directors to determine their own remuneration, their own payment? Don't forget that directors work so hard. If the company will do well, it's as a result of their hard work. If the company will not do well, it's as a result of their hard work. So will you argue that directors should be allowed to determine their own remuneration, or you think that there is a danger in that particular way? Yes, if you want to speak, just pick up your hand. The part-timers, I haven't heard. Yes, Beverly Mensah. Beverly. Okay, any other person? Yeah, so the question is that, do you support the proposition that directors should be allowed to determine their own remuneration? Yes, Jude.
Hello, sir. Hello.
Yes, Jude.
So I believe
I know the rest will not talk,
when
so you and I are doing the discussion on their behalf, isn't it? Okay, go ahead, Jude.
say I believe is giving the directors powers to the power to determine their salary will be mental. In the sense that they when it comes to economics, there's something which is called
Something is called what?
incentive.
It's called what?
Incentives,
Incentive, yes.
incentives.
Okay.
Their remunerations will serve as incentives for them to boost them in their performance, giving them the power to determine their salary would be detrimental. They might slack in their work. And also giving them also has, it's more or less like it has its advantages and disadvantages. And the disadvantage is that it might make them slack in their work. And the advantage is that it might more or less be a source of income. They could use it for a boost. It could also empower them to work harder and work more for the company. That's what I believe.
Okay, thank you, Jude. Any other person? Any show of hands? Let me see. Any show of hands? No. Okay, so well, okay, Amma Densha. Amma, let me make you a co-host too.
So I think directors should be allowed to decide on their or determine their own salaries, because they should be able to do that, but subject to maybe the supervision of another body. So for example, the shareholders can also more or less influence that decision by just maybe looking at the suggestion that directors make. But ideally, directors should be able to determine their salaries, but subject to maybe the acceptance or the acceptance of it by the members of the company.
Okay. All right, thank you. I've seen Elenam. Yes. Still gone? Okay, Elenam. Yes. Yes, go ahead, Samuel.
Hello, sir.
Yes.
Please, I think I agree with Amma in the sense that directors should be allowed to determine their salaries or remunerations. But then, like she said, should be subject to certain conditions, which the certain conditions or threshold. So, for example, a maximum percentage which the directors cannot exceed. So that one would check that they don't abuse that privilege that's given to them, and also serve as incentive for them to continue their good work for the progress of the company.
Okay. All right. Thank you, Samuel. Yeah, Elenam, let's hear you before I'll conclude the debate and continue.
Yes, sir. Good evening.
Yes.
Please, my question. I'm actually a little bit at a loss in relation to the remuneration of the directors.
Okay.
And I want to find out
No,
because
we haven't discussed the rules yet. We just started, and I posed the question as whether you think it would be a good idea to allow directors to be the masters of how much they are paid. Yes.
Okay. So all right. So I think that there should be some checks and balances. But my loss was actually about whether there is, the members will supervise this fixing of director salary or remuneration. Because if it is not checked, there is a tendency that they may abuse it and then they may overpay themselves. The central point that I wanted to make was that at one AGM, there was a requisition to increase director salary, but the members voted that the director salary should be stayed. So that was my confusion as to whether the directors determine their salary or it is determined by the members of the company.
Okay.
Thank you, sir.
All right, good. Yeah, so all the arguments which have been canvassed are not new, because even as far back as 1963, when Professor Gawa made suggestions leading to the enactment of the repeal at 179, we look at Gawa's report at page 139 in relation to his commentary in relation to section 194, which was the provision on remuneration of directors, which has now been reenacted as section 185. Professor Gawa, among other things, argued, and I just quote the last paragraph of the commentary, commentary number 9, quote, "I'm hopeful that this session will do much to prevent one of the most common abuses, namely running companies for the sole benefit of the directors, who take everything by way of remuneration, leaving nothing for shareholders. I can see no reason why it will prove unduly restrictive. It merely forces directors to come clean and to justify themselves to the shareholders instead of being sole judges in their own cause," unquote. So this commentary by Gawa, as you notice, actually mirrors the thrust of submissions that you have made, that yes, if you allow directors to determine remuneration, one rare risk is that the directors may give fat remuneration or emoluments to themselves, to the detriment of shareholders, in the sense that only very little, or there'll be nothing left by way of dividends to be paid to shareholders. And you begin to ask yourself, the shareholders put their money in the company only to fatten the pockets of directors, or to enable them get some returns on their businesses. So that is that. And well, the other side is also that, and like the example that Elinam has brought up, and I've also witnessed it in some AGMs, where you go to the AGM and you see that the company has not either made huge profits, but for a long time, the directors' remuneration have stood at one particular level, and they are requesting for increments by the company through the shareholders' resolution. And you get shareholders or members who will gang up and say that the director's remuneration, and usually if you go in their same tree, they'll say that entran, meaning that it remain as it is. There should be no increase. And that suggests a tension between interests of directors and then interests of what we call the shareholders. Directors want more remuneration, shareholders will want more profit, so that more dividends and so on. And that is why we have section 185, which has been carefully crafted to negotiate a fine balance between these seemingly tension, shareholders and then the directors on one hand. So let us look at 185 2.
1852. The fees payable to the directors as directors shall be determined from time to time by ordinary resolution of the company and not in any other way.
Okay, yeah, so the shareholders who actually pass resolution, meaning that, of course, the directors will usually bring the package. They will put something together. What they put together is actually not final until it has been sanctioned by shareholders' approval in the form of a resolution. So let us keep that in mind. But I want us to pay attention to the subsection 5. Subsection 5. Subsection 5, yes.
Subsection 5. The registered constitution of a company may make provision for benefits payable to directors, including A, compensation for loss of employment as director or former director, B, insurance benefits, and C, other indemnities.
Okay, yeah, so there is nothing wrong if the company, for example, has a registered constitution and it wants to make some detailed arrangement for directors. For example, compensation for loss of employment as a director. Maybe somebody is a director and probably is either a retiree and all that he's doing is a directorship work. So if he should lose that, he's lost his livelihood, and so on. So something may have to be done. Or insurance. Some companies do insurance for their directors, health insurance, life insurance, and so on, and some other things. But section 185 should be also read with section 206, payment to directors for loss of office. So let us look at payment to directors for loss of office. 206, please.
206. Payments to directors for loss of office. 1. A company shall not make a payment to a director or former director of the company or an associated company A by way of compensation for loss of an office in the company or an associated company, or B, as consideration for or in connection with retirement from office of that director or former director, without particulars of the proposed payment, including the amount of the payment, being disclosed to the members of the company, and the proposal being approved by an ordinary resolution of the company, agreed to or passed in the manner provided by section 193.
Okay, now, let me summarize 206 and then you read the rest of the two subsections on your own. Now, 206 is very relevant what we have discussed under 185 subsection 5. Now, sometimes there is what we call the takeover or what we call the mergers and acquisition, right? Maybe there's a company A and company B may be interested in buying almost all the shares of company A so that it will also dissolve the board of directors of that company whose shares are being completely purchased and so on and so forth. And they will make a proposal, right? They make a bid, and as part of the bid, they may want to entice the directors of the company that they are trying to acquire shares for them to, convince the shareholders to agree. And they may promise the directors that because you are going to lose your position as directors of this company that you are going to acquire, we would like to pay you this amount of money as a compensation for the loss of directorship. So that is what section 206 is speaking to. And later on, as we discuss duties of directors, you note that a promise payment of compensation for loss of directorship because the particular company is going to be acquired by another company could be a way by which the directors of the company whose, sorry, my battery is low. Let me put the battery on. This will go up soon. 1 minute. Okay, so I've done it. Yeah. So that is what section 206 is speaking to, that the directors by their own cannot actually make an arrangement to accept any promise compensation for loss of office without it being approved by ordinary resolution of the shareholders. So let us keep that in mind. And just before we go, with respect to the, let's look at how a director may be removed. And this is a very important aspect of directors, which should be a convenient point for us to end. And then the next class, we discuss duties of directors, and I think we are done with directors. So let's discuss removal of directors. Yeah, so yeah, Rita.
Yes, please. Please, the section.
Oh, Rita, I thought I'm running the class with you.
Please, the section.
176. No.
6. Okay. Removal of directors. 1761. Subject to section 327 and to this section, a company may, by ordinary resolution at a general meeting, remove from office all or any of the directors, despite anything in the constitution of that company or in an agreement with the director.
Okay, so this is quite pertinent. That is, directors are never assured irremovability. They can rather be removed by shareholders. And there's nothing wrong for the shareholders to pass resolution saying that all directors are going to be removed. And that is really permitted by law. So that is very important, except that, as we notice very soon, where directors are to be removed upon stated grounds, then they are also entitled to certain legal protection as far as their rights are concerned, including natural justice and so on and so forth. So let us look at the details rule. We'll come and discuss section 327, which governs cumulative voting, and how, because of cumulative voting, it may not be practical to remove certain directors by ordinary resolution. We discussed that pretty soon. So when we are done with 176, we go to 327 to discuss the concept of cumulative voting as applies to public companies and how that may pose a challenge to the facility of removal provided under section 176. So let's look at 176(2).
Yes, please. 1762. A resolution to remove a director shall not be moved at a general meeting unless notice of the intention to move the resolution has been given to the company not less than 35 days before the meeting at which the resolution is to be moved.
Okay, so this provision safeguards the right of the person to be removed as a director. And you are supposed to be, the intention is to move a resolution to remove the director is actually made known 35 days before the meeting. And this is important to enable members to also think through, to enable the person who is going to be removed to also organize his defense or his explanation, so that during the meeting, he too will be able to put up his defense or his explanation. So let's imagine you're a lawyer and somebody has been removed as a director, and then the person has come to you for legal advice. Part of the things that we want to find out, the manner in which the removal took place, the notice leading to the meeting during which the removal was done, and as whether during that meeting, the person to remove was given the opportunity to explain his side of allegations made against him, and so on and so forth. Good. So let's look at subsection 3.
Subsection 3. If after notice of the intention to move the resolution is given to the company, a meeting is called for a date 35 days or less after the notice has been given, the notice is properly given for the purposes of subsection 2.
Yeah, so just talking about where the length of a notice of convening meeting may not have to await the 35 days of the service of the intention to move a resolution for removal of the directors to actually run out before we can organize the meeting at which the resolution will be considered. And if we look at the subsection 4 and 5, essentially the points being made are what we call the procedural safeguard for the director who is to be removed, that he should be given enough notice, right? He should be given enough notice, and if nothing at all, he should not have less than 21 days. 21 days notice of the motion or not of the proposed resolution to remove him before the meeting is actually held. So if you look at it, the person who wants to sponsor the motion must bring it to the attention of the company 35 days before. And then the person against whom the motion is going to be moved for removal must also have at least 21 days awareness or notice before the meeting is actually convened. And that person is assured the right to be heard on the resolution and is also entitled to send a written statement. So if you get the notice that Mr. A, you have to be removed as a director, and then the grounds are given and all that, you also have the right to write your response and have it circulated to all those who are entitled to attend that meeting. So that way, they will have a balanced view before the meeting is held. And but if we look at the subsection 6, let's say subsection 6.
Subsection 6. The company is not required to send or circulate the statement if A, the statement is received by the company less than 7 days before the meeting, or B, the courts on the application by the company or any other person who claims to be aggrieved so orders on being satisfied that I, the statement is unreasonably long, or II, the rights conferred by this section are being abused to secure needless publicity for defamatory matter, and the courts may order the cost of the applicant to be paid in whole or in part by the director, although the director is not a party to the application.
Okay, good. Yeah, so much as the law would like to safeguard the right of the director who is going to be removed, at the same time, it must also check abuses. The director is entitled to have his response to the allegations circulated to those who are entitled to attend the meeting, but there are timelines. There are timelines, and that is why we are told that he should give the company not less than 7 days. Otherwise, the company can choose not to circulate it. And again, it should also not be too long. The explanation should not be too long, and it should not be a catch so as to indirectly defame some other people. But I mean, for the defamation side, we cannot understand that that is fair. But my concern is about the timeline for the circulation of the explanation and also the length of it, especially so when we are in a modern technological world of communication. So maybe in the past, you say that you have to do either post or courier, And because of that, you need no time to get the letters posted or to get the DHL or the EMS and so on. But now that we have email, we have various platforms, WhatsApp, Telegram, and so on, one will want to question whether the provision, section 176, subsection 6, and insisting that if the person to be removed does not get his statement at least 7 days before, the company does not have to circulate this, whether it is really relevant, especially so if the statement can just be circulated to all members just as a click. On the other hand, if we want to understand it, not from the statement being actually delivered to those who are supposed to attend the meeting as the only important factor, but also the fact that those who are supposed to attend the meeting must be given ample opportunity to read the statement, to digest it, reflect it, and form their own opinion before they come to the meeting, then we may not have any difficulty with the provision in subsection 6 of section 117 says that where you do not let the company get your explanation before the meeting, then the company is not obliged to actually circulate the statement. That could be appreciated within that context as it were. Now let's look at if there's this thing we'll be discussing later on, what they call the rule against oppression, or the rule in force and habital, protection of minority. And we come across a very interesting case, the case of Pinaman and Abroka. Let me see if I can show that with you. The case of Pinaman and Abroka, and that is relevant in discussion of directors. Is an, well, not too old, 1991 decision. And what happened in Pinaman and Abroka, as you see, is that someone brought an application under section 218 complaining of oppression, and he needed a remedy against oppression. And within the context of that particular application, he also requested the court to order removal of a director that he complained of as being, if you like, responsible for the company, indulging in oppression or oppressing his interests or doing things which undermine his interests as a proper member of the company. Now the courts, that's the Court of Appeal, made the point that where application has been brought under the section 218 of the Repeal Act 179 for remedy against oppression, the court does not have the power. The court does not have the power, for example, to order removal of a director. And the court emphasized that where the law has provided a particular procedure for achieving a certain result or a certain outcome, that procedure must be resorted to first. In other words, there's a procedure under the Companies Act for removal of directors. And under the current Act 992, we've seen that that procedure is under section 176. So section 176 of Act 992 is quite clear regarding how you can get a director removed. So the Court of Appeal in Pinaman and Abraka was making the point that insofar as there is a prescribed procedure for removal of directors, it is not proper for that procedure to be ignored and for you to rush under another provision, which is for a particular purpose. That is like the provision relating to remedy against oppression, and invite the court to actually remove a director when you have not exhausted, the procedure for removal of directors under section 176, which used to be 185. So please look at the case of the Pinaman and Abroka. And just before we end the class tonight, let us look at subsection 8 and 9 of Act 176. So subsection 8.
Subsection 8 and 9. A vacancy created by the removal of a director under the section, if not filled at the meeting at which the director is removed, may be filled as the casual vacancy in accordance with section 172. 9. This section does not.
Yeah, go ahead.
This section does not deprive a director who has a service agreement with the company of a right to A, compensation to which the director may lawfully be entitled under that agreement on the termination of the directorship, or B, damages if the removal from the directorship constitutes a breach of the service agreement.
Okay, good. Yeah, so section 176, subsection 8 is telling us that where a director has a removed in accordance with section 176, that is an instance of casual vacancy. And for that matter, the casual vacancy may be filled if not filled at the meeting at which the removal took place. But then more importantly, subsection 9 is reminding us that in the case of director with service agreement, if you say director with service agreement, you are referring to executive directors, right? Directors with service agreement, where the person has removed as a director. And if, for example, in the service agreement, there is a provision which seeks to protect, let's say that the employment or the particular services which the person is providing to the company in addition to being a director, then if the person is removed under section 176, that person may be entitled to the necessary compensation. So that is what section 176(9) is reminding us. So I will take any questions that you may have, and then we will end the class tonight. So the next class, we discuss duties and limitations of powers of directors, and then we should be done with directors. Any question or comment or contribution?
No, please.
Yes, please, go ahead. Yeah, somebody is saying that I should give slides. Well, let me suggest that I don't have any thing different from the provisions that we are reading, and that is where if I cite a case, then I rather give you the case. What I'll do, I'll send you like the case list and then the provisions. But the slides I'm showing you are just the provisions that we've just put over there. And as I always mention, and not just as Alfred or President Omni said, the proper way to learn company law is to read the law itself. I always say that, and I'll reiterate that. The law is the legislation and the related legislation and those cases that we cite. So that is what we should engage itself, and not the paraphrasing of the provisions that we do. Okay, so since I'm not seeing any hand, Thank you very much for coming. Have a very good night. Thank you.